Thank you, Cara. Kelley?
Thank you very much. Well, it's lovely to be a part of a very esteemed panel here this morning, and thank you for the invitation to join you. For the remaining portion of the program, I think what will be really a wonderful sort of continuum perspective is that I will be speaking from what we're seeing at the law firms for our clients. I advise a lot of CSV, CSPs, and cloud vendors, clients. I think we'll hear from the perspective of the software industry, and then certainly, and of great interest to me, of course, as someone who at the state level has been working on this issue, and Washington certainly has done so, and done so very well. My name is Kelley Miller. I am an associate at Reed Smith. I'm based out of the Philadelphia and Washington offices, and I'm one of 35 attorneys in our state tax practice. Since 2010, I would say a large portion of my practice has been advising cloud service vendors, CSVs, cloud service providers, CSPs, cloud service customers, and who are often called clients, and their customers. So that is the paradigm from which I approach this topic. What are some of the issues that we see in the practice? Well, we certainly see this issue of cloud computing come up. And when did it really start? When did we see what Malcolm Gladwell would call the tipping point for cloud? And I think that happened about 2 years ago, where we saw, Microsoft had this wonderful ad campaign where people were stuck in an airport and they wanted to download their photos. and they said, let's go to the cloud. And Apple had a wonderful marketing campaign where they said, if you have 17,000 CDs and you want to load them into our cloud-based music service through iTunes, you can go to the cloud. And before you knew it, even people like my 74-year-old mother, and she hates when I say that, but I say it to this point, she has an iPhone, an iPad, and uses the Facebook. And she knows what the cloud is. So inevitably, the time was going to come when the states were going to see the cloud as a source of revenue and begin to look at it and say, how do we tax this? So cloud computing, as Cara has so perfectly described it, has become this term that really at base describes the delivery of software, platforms, and infrastructure to users over the internet. The term has, I think, also become a panacea for a host of other problems in computer service providing and technology, but nonetheless, that's what cloud is. It's delivery of software, it's delivery of platform, it's delivery of infrastructure over the internet. The interesting challenge that comes to us when thinking about how we tax the cloud is how we take the component parts of these transactions, how we break them down, and how we apply them to a corpus of law that, quite frankly, has been rather static and stagnant over the past few years. And what do I mean by that? Well, as Cara alluded to, we have the states that had to define what tangible personal property was in their sales and use tax codes eons ago. And we saw the development of those definitions to include things that could be touched, seen, felt, perceived by the senses. Some states went so far as to specifically include types of software, be it canned software, be it some states even have gone into custom software. So we've seen the expansion of that definition. So that's there, but it's been there for a while, all right? Then we've seen the states put into buckets what are enumerated taxable services, and things that are not included in that bucket of what's specifically enumerated as taxable is not taxable. We're seeing services expand. But my point is that we have these two buckets, TPP and services, where the law has been rather stagnant. Where we're seeing development is that we're seeing the states want to catch up with technology. And I think we can all agree that the problem with trying to catch the law up to technology is that technology is evolving faster than the law. So the states are caught on a racetrack, if you will, where they keep trying to go around and around and catch the checkered flag, but the checkered flag keeps changing, keeps moving. The race pace keeps quickening, and the states are having a harder time keeping up with that. Do we commit to a law change and then have that law change not match the technology? Next week, in fact, in Philadelphia, Google is set to introduce what is going to be the next wave in cloud technology. I'm going to be very interested to go to that presentation because, obviously that will be newer and better wheels, newer and better clouds to go to. So we'll see what the states will have to do. But keeping up with this sort of steeplechase is very hard. I also hear a lot of commentators say, well, this is so tough because the states are really all over the map. And I'll be honest with you, from practice, I don't necessarily see it that way. I think that's a very simplistic and dismissive way to say, well, the states are all over the place. To be sure, you have to look at how each state defines TPP, how they define services, how they look at the taxation of a lease or a license of TPP as a license of software. You have to look at those issues state by state. However, I really think the states have put their guidance into 4 buckets: 2 taxable, 2 not taxable. You have those states that are taxing cloud, and Cara's absolutely right. The states have really only looked so far at software as a service. PaaS, platform as a service, and IaaS, which you've talked about, and you're absolutely right. It's more platform, it's more network, it's more, in my opinion, maybe more provision of services, have really yet to be tackled by the states. And you wrote a great article, I think last year, on is PaaS next, that we talked about, and I think it will be. But when it comes to SaaS transactions, the states really look at them, I think, in 4 ways. They either say taxable is an enumerated taxable service, right? So if we look at New York's guidance, for example, I think we have an example of a state that points in that direction, or a specifically enumerated non-taxable service, or they say it's a service that's really standing in place of a taxable product, i.e. TPP, or it's treated as a license of TPP. What's a great example of that, if you want to look at the Arizona TIR that came out in 2010, it's 10-007, for those of us who know it well. It was dead on, because people ask me all the time, is there a state that has actually used cloud computing in a ruling? Yes, there is. Our friends in Arizona who said cloud computing is akin to the license of TPP, and that's right there in the ruling for those of us to see. And there are other states that have followed that. Pennsylvania certainly picked up that language in its prior guidance before it changed it last year. And then fourth, you have finally cloud is something that doesn't fit into the state's definition of a taxable product, and therefore it's not taxable. So a couple ways they tax it, a couple ways they treat it as non-taxable. But I really think the first step in analyzing any cloud computing transaction is to look at what is in the Cloud Services Agreement, the CSA. And in the practice, we spend a lot of our time advising clients who are CSVs or CSPs or their customers or their clients on what is in the Cloud Services Agreement. And that's something specifically I'm going to spend some time speaking to, because if you are in the practice and you are working with CSVs or CSPs, that agreement is what is going to be looked at on audit. And I already have clients that are under audit in many states, and the issue that we point back to, the evidentiary piece of what are we providing, is the Cloud Services Agreement. So the Cloud Services Agreement is very crucial. And it's the first step in sort of analyzing the cloud transaction. So possible characterizations that can emanate out of a CSA analysis, a Cloud Services Agreement analysis, could be that the cloud provider is offering a service, or the cloud provider is offering a sale or a lease or a license of software or to a platform or the infrastructure. And it's a very important first step to look at what the CSA is saying is being provided. Why is that? Well, sales and leases and licenses, we know, generally involve some type of transfer of some rights to the product to that customer. And transactions that fall within more of the provision of services, however, may or may not involve these transfers. So this first step in really examining what the true character of what is being offered by the CSP does start, really, in my opinion, with whether or not there's been any transfer of rights between the provider and the customer. And if not, is this more cast as a provision of services? And even if the latter, even if it is a provision of services, in the absence of there not being any transfer of rights, could a jurisdiction even elect to treat the product, irrespective of the characterization of a service, as TPP? So it's a very muddled line of analysis that we go through, but we start with the CSA. And again, when we talk about specific states and how they've approached this, do they actually, go to the definition of software specific guidance? And they do. For example, why this is important is if it's deemed to be a transfer of a license or a license to software. Florida, for example, in a recent ruling said that the license to use software is not taxable, it's delivered electronically. And that ruling has actually stood now for about 2 years. Nebraska contrastly says that when you have an application service provider, or a SaaS, and they've retained title to the software and they haven't granted a license with ownership rights to the user or customer, that is specifically not taxable. And that ruling came out all the way back in 2011, and it has stood now for almost going on a year and a half, 2 years. So you want to look really specifically to the Cloud Services Agreement. I think it's also important to talk a little bit about what these relationships look like. And I wanted to sort of bring to the table what a typical client looks like for us. We have a client that is a cloud service vendor, cloud service provider, and I'll say hypothetically that this vendor is headquartered in California, and they develop and sell access to a proprietary software to their clients. And the software actually allows the clients to supplement their customer service offerings that they have internally with their company. And what it allows the client's customers to do is to use a PDA or a laptop or Twitter to interact with customer service so that they get immediate response. So you're not putting the burden on that company's customer service personnel to respond to their customers. You're actually putting that in the cloud, and you're able to get automated responses and help for the customers to have at a moment's notice. So when a customer has a customer service inquiry, they submit the inquiry using their PDA or Twitter or their handheld device to the company's software system, which is housed on various and multiple servers. And for the purposes of this analysis, these servers are located in Texas, Illinois, and New York. And I'm using those 3 states because those are 3 states where I would not want to put my servers, but let's say that they are there. I bring them out because they're states that have looked at server presence, and they've looked at it critically from a sales and use tax perspective and also from an income tax perspective. My client pays a subscription fee that allows its customers to use this product, and the terms of the CSA in this case actually provide that the client has no property rights to the software other than being able to access it online during their subscription period. So when the subscription period ends, so too does their access to the software end. And when their customers submit a request, they can be located anywhere, but all of the requests are processed through the servers in those 3 states. So that's a very typical type of transaction. So what is underlying the transaction between the CSV, CSP, and my client, who is their customer? Well, it's a cloud services agreement. And what are some things in the cloud services agreement that are covered? Well, in this case, the cloud services agreement is really only covering the fact that you have software that's being housed and run for the client. Data network, platform infrastructure, and hardware, which are really the monikers and hallmarks of PAS and IaaS, are not being provided. They're being provided by a third-party service provider. And that's very typical right now in cloud transactions. So with SaaS, ASPs, you're usually seeing only the provision of or the ability to run the software, and you're not seeing the infrastructure, the data network, or the platform, because they're for PaaS and for IaaS. But it raises 2 issues for us for tax considerations looking to the CSA. The company is hosting software and receiving income from the subscriptions to that software. So we bring up the sourcing issues, we bring up COP, is it market-based, is it based to where the location of the server is, which, as Cara said, is what a lot of companies are doing, and you're absolutely right, that's the default. And you also have a company that's selling a subscription to the service, which raises the host of sales and use tax issues. So the one question that I always have when I look at the CSA is the company actually transferring software? Are they transferring software, or is this are there any rights? Is there any ownership? What do we point to? And I want to defer here for a second, because even though we're here to discuss state taxation, we can't ignore, I really don't think, the body of guidance on the federal side, especially the -18 reg, right? -18 reg and 7701E. And the -18 reg basically classifies the transaction as a transfer of computer software, which is tantamount, really, to the transfer of a copyright product. The federal reg, the -18 reg, looks at this as akin to the transfer of, say, an ebook, okay? And so But even still, though, under the -18 paradigm, we have to contemplate the nature of that transfer. Is it a lease? Is it a license? And when considering whether or not the transaction is a sale, a lease, or a rental, we have to consider, under -18's paradigm, but I think also as applied to the state analysis, whether or not we have the burdens of ownership in the software that have been transferred. It's a key and critical analysis that we have when we look at the CSA agreements. And then two, we also have 7701E, and 7701E is sort of the paradigm, and I will say this as a caveat. The -18 rules, I know, are only intended to apply to subchapter N, which is are the international tax provisions and certain other code sections. But I do still think they're important guidance, and they have been looked at by the states, and I think they will continue to be looked at by the states. 7701E sets us a paradigm to determine whether the service contract is to be treated as a lease for federal tax purposes. And there's 6 prongs under 7701E that are looked to analyze and answer that question. And the main ones that in my opinion, are if the service recipient is in physical possession of the property, do they have a significant possessory interest of the property? And the last one I think is important too, because we look at this when pricing when we do CSAs, is the total contract price substantially excessive of the rental value of the property? And you might say, well, okay, those are 6 things we can look at, but they're in the federal code. Keep in mind, California is one state that has codified 7701E into their revenue and tax code. So we do have states that are looking to that standard. So we have that paradigm underneath us. Also keep in mind, I think it was the 2002 Illinois case of TV Guide, where TV Guide was paying for the ability to use satellites that were 22,000 feet above Earth's atmosphere, and they were using those satellites to beam down, right, the TV Guide network, which is a very fascinating case as somebody who has been known to spend a few hours look at the TV Guide network, you can see everything it's on, it's very nice. But they were using the satellites to do that, and the question there was whether, of course, it was a lease of TPP or a service being provided. And again, they went to the agreement. The court went to the agreement in that case and looked at the fact that even though services were discussed in the agreement ad nauseum, services here, services there, it really was, when you boiled it down and looked at the agreement, it really was not services but a lease of TPP. And here is a great example of, I think, one of the first examples, before we even had cloud computing come into vogue, of where you saw the court come into the fray and go to the agreement. So what should be in a cloud computing agreement? What do we see in cloud computing services agreements? And how do they come into light? If you remember, it was probably, I think, a few months ago now, where Amazon got into trouble because, of course, Amazon and Google, as you mentioned, Cara, have these very large infrastructures for maintaining cloud services for customers. And Amazon had a little snafu because theirs went down. And their customers were very upset that it went down. And I think, in fact, they tried to shift some of the services out here to Northern Virginia, or maybe it was the other way, Northern Virginia to Washington, I'm not sure. But the takeaway was there was a big mistake. There was a big problem. It was a boo-boo. And so what came into light when the customers raised a brouhaha was the CSA. And they pointed to terms in the CSA that said, well, what happens when we have this wonderful national, global, really, data migration ability to offload this data amongst many server farms? Well, what happens when they all go down? What are my legal rights as a customer? So we saw CSAs come into vogue there. From our perspective at our firm, we're the 10th largest law firm in the world, so we see customers come to us with these CSAs that are coming from the corporate side. And it's funny because that's really how we first started to do this, is that we got the clients from our corporate practice, our business development practice, because they were looking to our counsel, our attorneys at Reed Smith, to advise them on all of these legal details of these agreements. And what do I mean by them? Well, the privacy concerns, the data security, the service suspension and termination, this Amazon problem, indemnification for IP infringement, legal process for e-discovery, the EU data protection laws, if it was a university or college, and we have those clients as well, for the FERPA rules. So those are the legal considerations in these cloud services agreements. And then all of a sudden, we thought in the tax group, well, wait a second. what about the tax considerations? Because if you're writing these CSAs and the services are going to go on audit, or we're going to see income tax audits where the income from the revenues from subscriptions is going to be an issue, these CSAs are going to come back to haunt us in audit. So we need to be aware of what provisions in the CSAs may have tax implications. And there are 6 of them that do have tax implications, in my opinion, that I've seen and worked with, and I just wanted to give a high-level overview of what they are. The location of data. Often in a cloud services agreement, you're going to have a clause governing where the data is located, and some contracts do say that they expressly reserve the right to store customer data in a particular forum or jurisdiction. So dispersed geographical data, which we know is the key, can be beneficial, but you need to consider in that language the implications of data storage location in a particular forum or jurisdiction, especially if that jurisdiction looks to server location as impetus to tax. So if you have a server in a particular state and that state looks to the server as evidence of nexus, which used to be the PA rule. Pennsylvania changed its rule. It used to base nexus on location of the server, and it now bases nexus on the location of the end user, as Cara has mentioned. It's a shift in their guidance. But there are some states that are still looking to server. So that's one aspect for location of data that you need to be aware of when doing a cloud services agreement. Also, to ownership of data. Cloud services agreements usually will want to say that all of the data belongs to the clients and perhaps to the customers, depending on the software application being used. And the cloud service vendor or cloud service provider retains no rights or licenses in the data, just as the client may retain no rights or licenses to the software. And this is critical so as to avoid the ownership issue in jurisdictions that may be taxing this as a license to software. And again, you've got to know, you dance with who brung you for the jurisdiction, right? You've got to know what jurisdictions you have to be concerned about for your client. But when you know what jurisdictions you're aware of and you've boiled down how they're looking at cloud as a sale, a lease, transfer of rights, say we're in Arizona, you would want to look at the cloud services agreement and look at it critically to look at any language that might point to the license of TPP, because that, of course, would be taxable. And again, it's just important to know what the guidance says. And not so much we see clients not wanting to pay the tax. It's not much of a tax avoidance issue from a planning perspective, although we do have a modicum of that. But again, you just need to be aware of where you are. Cloud service agreement modifications. Some agreements allow the vendor to modify the services provided unilaterally. These are very standard agreements because they have been so fine-tuned on the legal side to be so cognizant of the license of software issues that they're not cognizant or thinking about the tax issues. So as counsel, as trusted advisor, you do have to look at it from how the tax issues are implicated in the CSA. And having this ability for the CSV or CSP to unilaterally modify the services can change dramatically your tax consequences. So limiting this right can also limit any unintended state tax consequences, and you can keep control of your facts, as I say to clients. When you keep control of the facts, you mitigate any unintended consequences. It's pretty simple. The fourth one is the governing law and jurisdiction. Usually the cloud service vendor or provider will say, if that's the jurisdiction of my state. As we know from just general legal parlance, you can say it's your own state. You can say disputes have to be brought in the jurisdiction of the defendant. You can delete the provision altogether. In my opinion, this is the best way to go, and open that up for later argument and resolution. And that tends to be sometimes more favorable if you're thinking about what jurisdiction you're going to have to be in later on for governing law. And the fifth and sixth are terminology. And terminology is probably the most important. And it goes back to the TV Guide case that I alluded to before. Services may not mean services. You really have to think about your use of the word services, your use of the word software. These terms must be very specifically defined and delineated as to what you're actually providing, or you're going to end up in the quagmire of TV Guide where you're going to leave it up to the court to decide, which you don't want to put your client in that position. And then finally, I would say this about fees, because fees tend to be something that's also included in the CSA and can have implications for state tax purposes. What do I mean by that? Flat fees usually indicate that it's a rental. Usually they're they're indicative of rentals and not of service provision. So just keep that in mind. The recommendations that I would offer here is that you make sure that your cloud service agreements and any other collateral materials, and I'm talking anything, especially on websites, because we know the departments of revenue in audit like to look at our clients' websites. And any collateral materials that you may have really need to be consistent so as to protect you on audit when it comes to what are you actually providing to the customers and then in turn to their clients. Where are your customers and end users located? Because that is a huge issue right now. That is also something that you need to be very considerate of. And I do think you need to look for states that do have favorable cloud treatment, and you can situs your operations there. My example with my client, where they're headquartered in California and have servers in Texas, New York, and Pennsylvania under the old rule, Pennsylvania under the new rule, they might be okay. Not a good example. That would be an example of not good planning. So that's really what I wanted to emphasize, was to talk about CSAs and to go forward on CSAs. And the last point I will say before turning it over to Mark is this. Is tax really a huge issue? Is taxing of the cloud this burden on our clients? And I do think that the cost savings in cloud infrastructure for my clients tends to outweigh the burdens of tax. I mean, it's such a savings for companies to take their data, migrate it, and put it in a cloud, okay? And that's becoming so more cost-effective as we're seeing more players entering the CSV and CSP environments. IaaS is projected to grow as a medium by 41% between now and 2016, according to at least one study that I've read, and I believe it. So I think you're going to see a lot of companies saying, you know what, we're not so concerned. I'm talking about the sales and use tax considerations. We're not so concerned there about the sales and use tax because we see it as just part of the cost of offsetting what is a very costly part of doing our business. Where I think we're going to see more development in this area is what we haven't been talking about that much, and it's on the income tax side, and it's on sourcing.